You may be seated.
Good morning, welcome to Lawrence County Municipal Court. I'm Judge Capper. Today is August 26th. We have reviews to do first for people who have obligations they've been court ordered to do. So this is a check on progress on the court orders. Your name's called, come up to the table to the right. Bail for call the reviews.
Haley M. Blake, Jeremy Butcher, Leroy Campbell, Jason Collier, Jeffrey Collins, Naaman Cox, Cody B. DeMint.
Haley Blake, 22760. She's at ODP.
And she is still compliant with treatment services.
Okay, and you can get me a letter
Yes.
on that? Thank you. That was bringing in Nick from ODP.
And then the community service, I just thought it was only on Tuesdays, but
Any day but Sunday.
that's,
I
just,
explained
yeah.
that to her this morning, so she plans on getting that done.
Okay, do you have any payment on your fines today?
I gotta go get money off my card.
Okay. Now, are you still doing the methadone, or
I've come down 50 milligrams.
what's the plan? Are you going to
I'm coming off of it.
totally, or are you
Yeah.
going to Suboxone, or?
I'm gonna come off of it, and I might do what is it?
Sublocade?
Yeah, the
Okay.
shot.
And once she's completely off of her methadone, because right now she's just doing mental health with OBP because she's also in the methadone clinic. So once she's finished with her methadone, then she can start doing all of her stuff at OBP.
Okay. So whether she'll do MAT or not, it's still kind of, I mean.
Yeah, that's up to
So
her.
you can switch at 35, right?
Once you get down to like 30 milligrams, you can go ahead and switch to like a different.
Okay, I'm going to set you for a month out, September 27th. That's Friday, September 27th. 9 o'clock.
You said 9?
Yes, ma'am.
Okay.
Thank you, Your Honor.
You're welcome.
Thank
Jeffrey
you.
Butcher is here, 19483, 19779, just paying off bonds. Do you have a payment today, Mr. Butcher?
Yes, 20.
Okay. And do you need to keep these on Monday, or does it matter?
It don't matter.
I'll set you for September 27th also.
Thank you.
That's a Friday, 9 a.m. See the clerk. Leroy Campbell is at RRS. Report from them, 12/30/25, 12/22/59, 10/6/27, those are the case numbers. Okay, it's a good report. And you're just paying on fines, so do you have a payment today?
I made a payment Friday, and I'm going to make another payment today, so
Okay, how much are you paying today?
25.
See the clerk for that. And I know you're working.
Yes.
Does it matter what day of the week your
No, they're
reviews
reasonable.
are? Okay, September 27th. That's a Friday.
Okay.
9 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
Jason Collier, 22275.
That's not ready.
22222, 218857. I'm going to pass this because I think, let's check it. I think it may be on the docket for September 23rd.
It is.
Okay. Pass it to September 23rd. Jeffrey Collins.
He's on Zoom, Your Honor.
All right, Mr. Collins is by teleconference, 19-1082, 19-304, 15-606. You're paying on your fines. You made a payment?
Yes, sir. Yes, sir.
When did you make a payment?
She made it this morning.
By online or in person?
Yeah, online.
Okay.
Online.
How much was that?
I think it's 225 on the other.
Okay, I'm not showing a payment. I know you've been saying you're making online payments, but I'm not showing one in the file.
It was made like, it's about an hour ago, unless they went through there or something, but it's everything, I got proof on my phone, that we went through it, we paid it.
There's nothing been paid on 19/10/82, let me look.
Yeah, okay. Okay, I'm gonna go ahead and I'll reschedule you for September 20th.
He's paid 30 on 19/304.
When? When's the last payment?
It was,
I'm showing something in May, was my last.
payment in the amount of $30 on September the 11th,
That's-
2023.
Yeah, okay.
Now, if you did make one online today, it will not go through until tomorrow, but I don't know.
All right, September 20th, and I want you to be here in person.
All right, thank you, Your Honor.
You're welcome. Naaman Cox, 23,569, 22,1663, 21,3062, 21,1917. 21,1917. Looks like it's finished. 21,3062. Still working on files. There's still community service on 22,1663.
Your Honor, if you don't want to say, last time I was in here, you was mentioning that you wanted me to do some community service. And the last time I turned in community service, they said that the way that breaks up on my different stuff, that it would only go towards my fines and it won't actually credit it as community service
Okay.
until I finish paying that next fine and then go into the next one. It costs me more money to do community service than it does to just actually work. I was hoping I could pay that fine off before I started on my next community service.
Okay, I'll let you do that as long as you're doing some community service. When people don't do anything, then we'll have to give a credit toward your
I
funds.
turned in more community service than what they accepted last time because they could only credit so much towards the fine I was paying on. So they ended up giving me, it was $50 a day or something, it was $50 a day or something. They credited.
We would have taken it and put $50 a day towards his fine, Your Honor, and then whenever that was paid up, all he could pay on, then we would have took his community service and applied it to his next case's community service.
Yeah. He still owes community service on his most recent
Yes.
case. And
Yes.
he still owes fines on a case that's older.
I'm making a payment today,
Okay, are you making a payment today?
Yes.
How much?
$100.
Okay. And you are working, right?
Yes,
What are you doing now?
I'll do logging.
Okay. For yourself or somebody else?
No, I work for someone else.
All right, I'll give you until October then, since you're making $100 payment. I'll set it for October 7th as your next hearing. And If you have questions about how this is applied, get with Mr. Major and discuss it, then I can intervene if you're not happy with the way it's being done.
Oh, I mean, it was fine. I was just hoping that I could hold off a little bit longer until it actually applies it as community service, because right now, if I take off work and do community service, it goes on my fine.
Well, if he's paying, I'm okay with him working on the other.
Yes, Your Honor, whenever Mr. Cooper gets back, we'll discuss it.
Okay. October 7th is your next hearing. See the clerk.
Thank you.
Cody Dement, 23-6. Cody Dement. He's done everything but the driver intervention part of it. There's no proof that he's done that. He was ordered to do that. So, now I'm showing, I'm showing he was actually given more time until October the 18th, so I don't know why it's in here. Yeah, it's set for October the 18th, so I'll pass it to October the 18th. Okay, that finishes the reviews. The next are the arraignment hearings, which are new cases. Anyone out in the hall that's got a new case, you need to come in now.
Arraignments need to be in the courtroom now. First time being in for court, missed a hearing, got a warrant.
Come in, have a seat, and I'm going to explain the rights of defendants. So we've got several arraignments today. Arraignments are what the hearing is called when a person first appears on a criminal charge. The purpose of the arraignment is to tell you what the charges are. This gentleman in his office is just came in the courtroom and decided, I don't have any say in what you get charged with. It may be totally bogus and false. I have no idea. I don't make the charging decisions. That's the prosecutor's job. So you don't need to agree with it, but you need to understand what you're charged with. So I'm going to tell you what the charges are and possible penalties. You have a right to remain silent. You don't have to say anything. If you choose to make statements, everything you say and everything I say, everything in here is being recorded. And now even the video, so it's audio and video is being recorded. So if you get up and admit stuff about your case, the prosecutor can use it against you. You don't have to say anything. You have a right to have a lawyer, to have one appointed if you can't afford one. You have a right to bail and to make the state prove any charge beyond a reasonable doubt. If you decide to enter guilty or no contest plea, you're giving up those rights I just explained to you. You should not do that. One, if you don't understand what's happening, do not enter a guilty plea or a no contest plea. If you want to talk to a lawyer, do not enter a guilty or no contest plea. If you want a trial on your case, do not enter a guilty or no contest plea. Do not enter a guilty or no contest plea to get things over. That's not a good reason to enter one of those pleas. The safest plea is always not guilty. Call the first case.
State of Ohio versus Kelly Key, case number CRA 24491. Your Honor, please control the suit.
All right, Ms. Key is appearing by teleconference, and she has an attorney present in court, Mr. DeLauder.
Yes, Your Honor. We'd waive a formal reading of the complaint, any defects in service. It's charged as a felony of the 5th degree possession case. However, we would like to request that this be set for a preliminary hearing on the 30th of September to allow Ms. Key some time to get things done on her end. In hopes that
if that's going to include going to treatment, right?
it is, Your Honor. That's the thing that she needs to get done on her end. And obviously, it won't be done by September 30th, but we'll at least allow her to get some progress made so that I can share that with Mr. Field.
Mr. Field.
We don't have an opposition to that. Is that Ms. Key on the screen?
Yes, she's on
Where
the
is
screen.
she now?
She lives in Florida.
Oh, We're not opposed to that. Of course, obviously, if she's going to go to treatment, I guess we need to, particularly if she's going to be in Florida, that complicates things a little bit.
Yeah, Ms. Key, what needs to happen here, and there's a lot your lawyer can explain in more detail to you. It's kind of a complicated system that we have that comes from old England. You have grand jury, you probably heard of grand jury. Grand jury, when you're charged with a felony, it's considered so significant and so serious, you have to be indicted by your fellow citizens. So what's happened here, you're not indicted yet, but a complaint's been filed alleging you did commit a felony. So you would have a right to have it presented to a grand jury for an indictment. But what your attorney is seeking from the court is not an indictment, but for your case to stay here in this court, at the arraignment level court, and never go to the grand jury. But for that to happen, what the state is saying they're willing to do is give you some time to get into a legitimate substance use program, show that you're doing that, compliant, and making a recovery, that you're going to be sober and get into recovery. And if you do that, then the state won't even take you to the grand jury. You won't get an indictment. You won't go to the felony court. This is complicated by the fact that you're not living in the local area. So, you know, if you were here locally, I would know what facilities, what treatment providers are available, and who's legit and who's not legit. I have no idea what treatment facilities are in Florida. So that burden of proof is going to be on you and Mr. Delauder. So I need proof that you're in a legitimate treatment facility, that you're getting legitimate drug screens, that you're getting legitimate counseling, and that you are making progress towards sobriety. If you do that, then your case won't go to the grand jury, you won't get indicted, and eventually, most likely, you could even get your case dismissed down the road, but that's going to take some time.
Okay.
And that's what, you understand that's what you're signing up for?
Yes, sir.
Okay. All right, with that understanding, and Mr. Delauder can go into it in more detail with you, I'm going to let her sign an OR bond. We'll fax it, you can get it faxed to her, $2,000 signature bond. That just means you're promising to come to court when you're ordered to.
Yes, sir.
Okay.
And on pain of having to pay $2,000 penalty if you don't show up. I'll set the next hearing at your request in September. You said September 30th?
If that's okay with the court, that's about a month away.
September 30th, and you're waiving time constraints. You have a right to make the state bring this to the grand jury within a certain time frame, and because we're going to give you time to keep it in this court and go to treatment, you're agreeing you're not going to require the state to get you indicted within that time frame. Do you understand that?
Yes, sir.
Okay. So on September the 30th, this will be set for a preliminary hearing at 10 o'clock. What I'll need to see presented to the court is satisfactory evidence of those treatment requirements that I just said. I want to see screens, and I want to see results of counseling. Don't come in on September 30th, which just happens sometimes. Somebody just showed up for their first assessment on the day before. You know, like September 29th, they went. They waited a whole month, and they go the day before their hearing to get an assessment. That doesn't show me good faith. That tells me that you're really not interested in getting clean, and I'm just going to tell the prosecutor, take it on down to Ironton to the grand jury and let them look at it. I don't want to deal with it here. This is, as I say all the time, this is a court for people who want to get clean. If you don't want to get clean, don't waste my time. Go down to common pleas, let one of those judges deal with you, because they can send you to prison. I can't send you to prison if I want to. I can only send you to the county jail. But if you want to get clean, I want to help you, and I'll be there rooting for you, monitoring your treatment, and eventually not even have an indictment on your record if you do what you're supposed to. Okay?
Thank you.
All right, September 30th, 10 o'clock is the next hearing.
Thank you, Your Honor. Your Honor, would you like for me to acknowledge her bond, or do you want me to figure out a way to scan that to her and get it back up here with her?
If you have her sign one.
Yes,
it's
sir.
in the back, please.
State of Ohio versus Nicholas W. Chapman, case number CRB 24490. Nicholas W. Chapman.
Yes. Nicholas Chapman.
You know, this form's over.
Okay, I'm going to pass this because I've got a summons, return of service that just says it was residential service, which means the summons was left at the residence. Doesn't say it was served on the defendant personally, so that's not good service. I'll pass it for service.
State of Ohio versus Donzie Goodson, case number CRB 24468.
Thank you, Your Honor.
Good morning, sir. Are you Donzie Goodson?
I am, sir.
Mr. Goodson, it's alleged that at Rome Township on July 21st, you entered on the land or premises of another person without the right to do so. So that's criminal trespass. It's a 4th-degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. Do you understand the charge?
I do, sir.
Do you understand your rights?
I do, sir.
How do you plead?
Not guilty.
You want a lawyer appointed to represent you?
I don't need a lawyer.
Well, do you have the money to hire one? I can appoint one for you if you qualify financially.
Your Honor, what's on this paper that was served to me is a lie.
Well, maybe you especially need a lawyer then if it's a lie.
Well, I'm not guilty, and I ain't gonna get no lawyer, and I ain't pleading guilty to something I didn't do. It's
I didn't ask you
extenuating
to plead guilty
circumstances.
to it. But do you have any income coming in?
I have disability, is all.
That's your only income?
Yes, sir.
I can appoint you a lawyer then.
All right, sir.
So, Abraham Lincoln said, "A man that represents himself as a fool for a client." So you don't want to be a fool. You need somebody to help represent you. So let's appoint Mr. Steyer to represent you.
And Your Honor, there's a cross-filing in this.
Oh, okay.
And I assume the other person's here for arraignment, or at least is set for arraignment, Sierra Massey.
All right, Mr. Steyer, 4th-degree misdemeanor. Do you have a Massey?
I do not know yet to do.
Okay, let's go ahead and call it, because apparently it's cross-filing.
State of Ohio versus Sierra Massey, case number CRB 24467.
And ma'am, you're Sierra Massey?
Yes, I am.
It's not the same charge, but it is on the same day. This alleges that at Rome Township on July 21st, you caused Donzie Goodson to believe you had caused physical harm to his person or property. Your charge was menacing, 4th-degree misdemeanor, maximum penalty 30 days in jail, $250 fine. Do you understand the charge?
Yes, I do.
How do you plead?
Not guilty.
Do you want a lawyer appointed?
Yes, please.
Are you working?
Yes.
What do you do?
I work in auto parts.
Are you paid by the hour?
Yes.
How much per hour?
$10.75.
Yeah, you're eligible for court-appointed counsel then. Mr. Holt, I just saw him pass through. Mr. Holt, this is Sierra Massey. She has a menacing, 4th-degree menacing charge. And these are, in effect, cross-filing. You got a criminal trespass and a menacing charge. Is there protection orders here requested? Do you each need order for the other one to stay away? Okay.
I'm sorry, you're requesting one? Yeah, we would like mutual, Your Honor.
Is there any problem with you all staying away from each other?
He's my next door neighbor.
Okay. But other than that, you
Okay, we
can
can ask.
Yeah, we can stay away from each other.
ignore each other?
Yeah.
Go the other way when you see? That's what you need to do. Just stay away from each other.
Your Honor, Mr. Goodson's indicating he has some property, some personal property on her property. We'd like to see if we can figure out a way to get that.
What would that be?
Your
I
Honor,
don't know
Yeah, I
what
want
it
to
is.
move.
Your Honor, I have a mobile home sitting up there. See, my sister owned that
Hey,
property.
hold on. We're not gonna talk about the case beyond what you have there.
Here's the mobile home is what we're talking
Yes.
about.
So if he makes arrangements to get that moved, you don't have an objection to that?
No, I don't.
Okay.
Is that the root of the problem? Is there,
Well, the root of the problem is he come after me. Well, he was told.
Here,
probably,
here, and here.
Excuse me.
I didn't know if this is something that could be resolved by having the lawyers.
So why don't we do that? Can we talk this over today and see if there's any resolution that can be reached before we come back for a hearing? So, Mr. Steyer, can you talk to Mr. Goodson?
Yeah.
Mr. Holt, talk to Ms. Nancy, then talk to each other, and the prosecutor, I'll recall this later in the docket to figure out when we're coming back for another hearing. And the lawyer probably wants the court, you want the court's files?
Yes, but can you grab one, the other one, JT? Thank you. All right. We're gonna go out in the lobby and I'll talk to you and then we'll talk to them.
The case will be recalled later in the docket.
Thank you.
State of Ohio versus Richard L. Taylor Jr., case number CRB 24469.
So are you Richard L. Taylor Jr.?
Yes, it is.
Mr. Taylor, you have a charge of assault. It's alleged that Perry Township, July 25th, 2024, you knowingly caused or attempted to cause physical harm to Carmi McGuffin. That's an assault charge, first degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Did you receive a copy of the charge?
Yes,
Do you understand your rights?
yes.
How do you want to plead to this?
Not guilty.
Do you wish a lawyer appointed to represent you?
Yes.
Do you have a job?
No disability.
I'll appoint Mr. Stratton to represent you. Entering a not guilty plea.
Yes.
Mr. Stratton, this is Richard Taylor. Has a M1 assault charge against him.
Yes.
He has appeared, so I'm going to let him sign a signature bond. Is there a protection order requested?
Yes, Your Honor.
He can sign a $1,500 OR bond. Is there any problem for Mr. Taylor to stay away from Ms. McGuffin? Or I guess that could be Miss or Mr.
No issues staying away.
Okay. Protection order issued.
Get you sign these just right there.
Okay.
We could set pre-trials on the 3rd, which is a Tuesday, the 6th, 13th. What's your preference?
Any of those days will work, Your Honor.
And I think you have already set stuff on that Tuesday, the 3rd.
Yes.
Okay, let's do that. September 3rd, for a pre-trial at 10 a.m.
Yes. All right, thank you, Your Honor.
Hold on.
All right, we'll step outside and talk.
State of Ohio versus David Dillon, case number CRA 19340.
This is an old case. You're David A. Dillon.
Yes, sir.
And you've received a copy of the charge.
Yes, no.
This charge alleges that on April the 6th of 2019, in Fayette Township, you can only cause Michael Sisler to believe you would cause serious physical harm to his person or property. That's a felony of the 5th degree. Maximum penalty is a year in jail, $2,500 fine. Do you understand the charge?
Yes, sir.
You have money to hire a lawyer?
Yes, sir.
Have you hired a lawyer?
Not yet.
Okay. Well, you have a right, I'm going to let you sign a signature bond. So you've got a right to have a hearing within 15 days for me to determine if there's probable cause for this case to go forward. And part of that is what I was talking about with the grand jury before, with that other lady. Since this is a felony, in this natural course of things, it would go on to the grand jury for an indictment. But you have a right for a judicial officer to look at it before it goes to the grand jury and say, is there enough evidence for this to even go to the grand jury? And you have a right to have that done within 15 days. You can waive that, and I can give you more time than 15 days. But if you want it done in 15 days, I'll set a hearing within 15 days. So it's up to you. Do you want to set in the next 15 days, or do you want more time than that?
15 days to be fine.
Okay. So let's set it. So that would be the 9th of September, 14 days. So I'll set it for September the 9th for a preliminary hearing, 10 o'clock. Since you came in on your own, I'm going to let you sign a signature bond of $2,000. You understand what that means?
The way I gather of understanding it is I sign my name, and if I don't appear,
Then you go to the 2,000. As long as you show up, you don't have to post the money.
Yes,
It's
sir.
like an IOU 2,000 if I don't show
I
up.
appreciate it, sir.
If you would sign right here, this is your OR bond.
I'm going to put down that you will hire counsel. Any questions, sir?
No, sir.
Okay. September 9th, 10 o'clock is your next hearing.
Thank you very much.
You're welcome.
State of Ohio versus Samuel Julian, case number TRC 231598, A and B, Mr. DeLauder's case.
Morning, Your Honor.
Set for pretrial.
It is, Your Honor. We had resolved this case at a prior pretrial after discussions with the bench. The state was agreeable to amend the charge to reckless driving based on evidentiary problems. However, they wanted Mr. Julian to complete a 72-hour driver intervention program. We were here once before, and the program had gotten rescheduled, not Mr. Julian's fault. He did complete it, though, and I've got his certificate, Madam President.
Yes.
This is actually a copy of this.
Okay, this is for the court's file.
Yes, sir.
Okay. Completed on August the 18th.
I provided a copy to Mr. Field also.
And it's going to be amended to what?
A 45-11-20, Judge, I believe it
Okay,
is.
reckless.
Yes.
There were some other conditions on that, too.
Yeah, there were, Judge. So,
1-year
Mr.
suspension is what I...
Yes, sir.
It looks like Judge Permeans no.
Yes, and also, we agreed on the higher end as far as the fine as well.
Okay.
That's correct, Your Honor. And he's currently under, just so you're clear on what we're proposing, he's been under an administrative license suspension. So it might be kind of routine for an ALS form to be submitted to the state terminating that. In this situation, there will not be a suggestion for that. So he'll continue under suspension until that expires.
So the year's up.
Yes, sir.
Okay, you agree with all that, Mr. Julian?
Yes.
Anything you want to tell me before I finalize this?
No, I just would like, I'm living with my neighbors right now. I actually just recently got kicked out of my house. So it's been rough. And so I'm living with my neighbor Bill. And right here, I'm living in this camper right now, so.
Okay.
No, but I'm just saying the fines, and the money's gonna be hard too. I'm trying to work some money as well.
Well, we accept payments and we'll work with you.
I appreciate it, thank you.
All right, on the amendment to reckless operation, I'll place a $150 fine. Court costs. How long do you think you need to pay that?
How much did you say it was?
It'll be 150, and court costs are 95, I believe, so.
I can probably pay it. I
Let's
can
leave the suspension.
I can probably pay it today, honestly. Well, give me like a day. I can make a phone call, probably make it today. $150.
Your Honor, he's going to try to pay that today.
Oh, okay.
I can get. I want to get this taken care of. So
I mean, I can give him a final pay date of November 26th.
I'll be way before that. I can.
Okay, thank you.
Okay. I'll give you a final, I'm not gonna put you on probation or anything. I'm just gonna give you what's called a final pay date. So you've got till November 26th,
Okay.
so that's right around Thanksgiving, to pay this. And if you don't pay it, then the clerk's gonna send it into the B&B and they'll suspend you for not paying it. But you've got all that time to get it done.
Okay.
All right, any questions?
Oh, no, Your Honor.
Okay, that's all.
Thank you.
And Your Honor, he had a mark language.
Oh, dismiss it.
Okay.
Thank you, Your Honor.
State of Ohio versus St. Michael. St. Michael, case number TRC 241460, A, B, C, D, and H.
Mr. McCown's case, set for pre-trial.
Good morning, Your Honor. Your Honor, it's my understanding after discussing the matter with the state, we demanded discovery, but there may be accompanying criminal charges that they're still trying to determine. So if we could continue this out, we'd waive time to September 6th. That would allow them to get me the information and us to potentially come to a resolution.
Okay, that would be fine. September 6th will be the next hearing date for pre-trial at 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Clarissa D. Freer, case number CRB 24500.
Your Honor, this is sort of a strange situation. That's a Rule 4 hearing. I don't believe she has turned herself in to Athens. I checked the docket this morning. It's still showing an active warrant, unless the docket's not updated from last week. I understand, however, that she's also on QRT and that she actually was in Ironton Court last week. So I'll let her speak a little bit more about that.
Yes, Your Honor, she didn't tell me that she had anything in any other counties, which is a question I specifically asked her. But she did sign up with QRT at Ironton Municipal Court last week.
Okay. She's got a warrant out of Athens County Municipal Court. It's a TRD case number, so that tells me it's a traffic. It's a driving, I'm looking for, it's a driving under suspension is what she had up there that they have a warrant for it on. She had appeared here
On the 12th, Your Honor.
on the 12th. I gave her till today to get that warrant lifted or show up here and explain why she didn't get it lifted, so.
I'm gonna try to call her again and see if I can get her here today.
Okay, so we'll just recall this later.
Yes.
I'll try my best.
Okay.
It means
All right.
that it's like versus the rain, it was not to be here.
It was, she waived it, it was set for a hearing today.
What was the date we did our arraignment?
August 12th.
I believe she bonded out, is what I believe she did.
Yeah, she had a, let's see, I said 500 cash insured. Yes. She did post a bond with Mr. Sowers. So I'll recall this later in the documents.
Thank you, Your Honor.
Thank you.
State of Ohio versus Carlos J. Police, case number CRB 2418. He's on Zoom, Your Honor.
Your Honor, he is not well today. He says he's not going to be able to make it today, so I told him to appear by video at least. He has paid the court costs. We don't have a letter about his counseling like the state wanted, so I think the state might be wanting to continue this pre-trial. Is that correct?
He has paid the court costs.
We also had requested as part of this that he do his anger management counseling. So I don't know if he has anything to show that he's doing that, or...
I have something to show that he is seeking services with a therapist. It's just not a letter explaining exactly what he has done and what he has not done.
Who is he seeing?
It is called... E-Therapy Pro. Well, it's an online therapy program. That's his counselor. Okay. So if we reset it to another date, Your Honor, he'll have a letter at that date.
Third, 6th, 13th.
13th might be okay, Your Honor. That'd be fine?
September 13th will be the next hearing at 10 o'clock.
Yes.
Furnish proof of counseling.
You heard all that. I hope. I never got a reply out of him.
Yeah.
Did you hear that?
Yeah,
Okay, all right, we're good then.
All right, thank you.
You're welcome.
State of Ohio versus Sherry Freaks, case number CRB 24195. Sherry Freaks.
Your Honor, this was a 90-day continuance. I have no problems. It was to be dismissed, and she did not have to appear if court calls were paid.
Court costs have been paid. State still willing to dismiss?
Yes, Your Honor.
Case is dismissed.
What about it says TPO continues, TPO dropped, or?
That's right, yeah. Goes with the case.
State of Ohio versus Amanda Thompson, case number CRB 1962 and CRB 2649. Amanda Thompson.
It's Mr. Stratton's case set for pretrial.
Yeah, I was concerned about this, Your Honor. I don't know where Amanda is.
I had a note that she was in labor previously.
Yeah.
But that's a month ago, so.
Yeah.
She should be available for that. Okay, she's got 7 days to get in before warrant issues.
Okay, thank you, Your Honor.
Who is that?
Amanda Thompson, 1962, 2649.
Well, one of those thefts are set for a review, Your Honor. The other ones have not been completed yet.
Okay. And let's see, both had OR bonds, there's no bond up on either one.
Okay.
State of Ohio versus Jose Silva, case number TRC 241289, A and B.
Good morning, Judge.
Good morning. Mr. Nash's case set for pretrial.
We have discussed the case with the State of Ohio. Discovery is complete. We'd like to review this for possible suppression. Is it possible we could reset this for October the 6th?
Mr. Heald?
We're not opposed to that. The original 90 days would run on September 21st, but there was a discovery demand made, but we're still getting kind of close.
I can do a time waiver.
Okay. state's agreeable with that then?
Sure, yes.
And you said the 6th of October? Or
Yes.
It'd be the 7th. 7th is a Monday, 6th is a Sunday.
Oh, I'm sorry, the 4th.
4th? All right, October, that's a Friday. October 4 will be the next hearing, it'll be a pre-trial, 10 o'clock, and that's at defendant's request.
Thank you, Judge.
You're welcome.
Leave. This continues.
State of Ohio versus Tammy Lewis, case number CRB 24477.
There is a co-defendant, I'm covering for Mr. Morford, but I can't cover this one. Luke is going to stand in with Mr. Clifford Jenkins. He's here. I just can't, he's the guy. And I think it's something, a problem, I've got the disc or the DVD this morning, flash drive rather. When I tried it last week, it was corrupt. Missy had trouble. I finally got the DVD. My client, I've looked at it briefly.
Let's call the other case.
State of Ohio versus Clifford E. Jenkins, case number CRB 24479.
This is Mr. Morford's case. He had texted me over the weekend that he was in the hospital. I'm not sure if he's out yet. He's not here today.
No, he thought he may be released this morning, but I've not had an update from his office, Judge, and I said I would stand in.
But this is a situation with co-defendants, so I'm going to stand in on this one.
So it's my understanding you're asking for continuance.
I think we have to, Judge, just given Mr. Stiers not familiar with the case. I just watched the DVD or the flash drive. I know it's inconvenient for my client. She's from near Cincinnati. But I don't feel comfortable going forward, just having received the DVD or the flash drive, rather. I think we will resolve it next time,
Okay.
one way or the other.
Since she's the one traveling, is there a preference for hearing date?
I find anybody to watch with my son. I hate for him because I have to come back. He has to miss school.
Unless you plead guilty right
No, I'm not doing it.
We got to come back there. Okay.
Like
Judge,
not the 2nd of October.
Okay.
I think that they will.
the only day that I have that I cannot be in September is the 20th. Other than that,
She has no preference.
The 17th, I have a doctor's appointment.
she has a doctor's appointment on the 17th. I don't know if that's a
Well,
Monday.
that's not a court date anyway.
Okay, because the 20th is the only bad day for me.
How about the 16th, and that's Monday?
I can do that. I
Monday
will
the
let
16th.
Susie know at Butch's office.
September the 16th will be the next hearings for both of these cases at 10 o'clock.
September 16th, 10 o'clock. Thank you, sir.
I don't want you to plead guilty. We'll talk about that. Thank you, Judge.
State of Ohio versus Tanner Click, case number CRB 24391.
This is Mr. Smith's case set for pretrial. Tanner Quick.
Yes.
Is Olivia Kraft here today?
He says she is. I don't know.
Olivia Kraft, would you come up and talk to the prosecutor, please?
Yes.
I assume the other gentleman is Trent. Are you Trent?
There are three brothers. I'll start with T, Judge. It's confusing.
Four brothers altogether.
Four brothers.
Yeah.
There's Tanner, Travis, Trent. Who's the other brother?
There's
Tyler, me, Trent, and Trevor. Yeah.
Approach, Your Honor.
Yes.
Well,
Does she still want a protection order?
do you want a protection order? She doesn't want a protection order.
Okay, I'm going to have that withdrawn, that Ms. Kraft's request, there was initially, which is common in this case, an order for him to stay away. Withdrawn at your request.
Yeah, just say you're doing what you're doing.
So continue about a month and let him get a report.
He will, Judge. He will bring a report next time. And hopefully that will be satisfactory and shed some light on this issue.
September 30th?
Yes, that's fine, Judge.
Next hearing is September 30th. Be looking for a report from Shawnee.
10 a.m.?
10 a.m., yes, sir.
Okay. Bring a report for Shawnee with you.
Okay.
All right?
Yep.
We'll see you then.
Your Honor.
State of Ohio versus Justin Michael Reaper, case number CRB 24226. Justin Michael Reaper.
Justin Reaper.
It's Mr. Morford's.
Three calls, Mr. Morford's case, right?
It is, and I don't know this gentleman. I don't know if he's here or not, but
Well, actually, he had failed to appear August the 12th,
oh,
and Mr. Morford asked for continuance then, which is granted, so there will be a warrant issued in 7 days. Yes.
I'll let Mr. Wolford know, Your Honor.
Thank you.
State of Ohio versus Ronald Spears, case number CRA 23611.
This is Mr. Morford's case set for proof.
It is, Judge.
I don't think that's all why anyway. They don't even have my address. I know they arrested somebody, don't even serve papers. Whatever, I mean, I don't care. They need to do other things instead of doing wrong people.
Judge, it sounds like, I don't know if we want to set it for a trial, maybe one more pre-trial. Mr. Wolford will have to be involved in this. He's not, well, I'll just leave it at that. I don't have to state
Have you had you even talked with Mr. Morford?
Yeah, no, I talked to his secretary.
Okay.
I'd like to have a chance to talk to Mr. Wolford. He's,
The information they got here ain't nothing. They ain't even got the right person on.
don't talk about your case because it's being recorded.
right.
Mr. He'll talk to you about it. He'll go all with you in his office.
State still wanting to go forward with this case?
At this time, we do, Your Honor.
Is Brad Richter here today?
He's not.
He never
Actually,
showed up.
Your Honor, we haven't been successful in contacting him up to this point, so what we would do is nolly the charge with the right to refile it if he should come forward.
Okay, Mr. Spears, that's a pretty good result for you. They're going to dismiss it with the right to refile it if they feel like that was a mistake. But
it's all wrong.
happened, so it's dismissed without prejudice.
All right, thank you.
You're welcome.
State of Ohio versus Leonard E. Johnson Jr., case number CRB 23401, CRA 22276, CRB 22278, CRB 17156.
This is Attorney Tyler Smith's case. And set for pre-trial. He's at ODP.
Yes, Your Honor, I emailed you a copy of his progress report. He is compliant with treatment, and he is planning on continuing services with OVP outpatient in Huntington whenever he discharges on 9/12.
Okay, so he's got a little ways to go.
Yes.
Your Honor, can I say something?
It's best to say it to your lawyer.
I think it's about his recovery.
Yeah.
I don't think it's anything.
Okay.
The first time I was in recovery, I was going through so many different distractions. I was going through a divorce, and I was just worried about too many things, and I wasn't focused on myself. You know, now I'm focused on myself more, and I put all my heart and soul into this time, and I'm ready for a change, and I look forward to see what the future holds for myself.
Okay, very good. Thank you for that. And looks like you got a good start, but as you may know, hopefully, this is start only, and you have to keep working at it.
Absolutely.
It's going to take some time, and take some effort on your part. It sounds like you're willing to do that.
Yes, sir.
And he's finishing September 12th? And you're going to go outpatient with ODP after that?
Yes, I've got, as soon as my out date, I got an appointment already scheduled for my out date for there.
Okay. Well, I'd like to come back after that to see how that's going. So what's your availability in September after the 12th?
Your Honor, I'm available the 16th or the 20th. I want to get that seen after the 12th.
Let's do the 20th.
Your Honor, I spoke with him this morning too, and he's willing to work with Thrive when you get better at OVP as well.
Okay, I'll refer you to Thrive for peer recovery coach. That was Juanita speaking from Thrive. I'm making a note of that. September 20th is your next hearing. 10 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
State of Ohio recalls Carissa D. Freer, case number CRB 24500.
Your Honor, we've attempted to contact her through text message and calls and able to reach her.
Your Honor, I've tried to reach her multiple times through phone calls and text messages, and I'm not getting any response at all.
She has a bond up with Mr. Sowers.
I think she was also supposed to be put into treatment, I understand that.
I tried to get her into treatment on Friday. Then she texted me at midnight Friday night and said that she just now saw my messages. Because she knew what I was doing.
Yeah. Well, she's avoiding what a reckoning, which is going to come. So I will have Mr. Sowers start hunting her down. Issue a bench warrant today. The failure to appear. Set a bond forfeiture hearing for September the 16th, and I'll notify Mr. Sowers of her failure to appear today. Yes, Your Honor.
Thank you, Your Honor.
Thank you.
Dismissal is one conspiracy, right?
Yes.
Go over here. Take this out of the table.
Okay. Chris Freer, there should be a warrant issued today with a bond forfeiture hearing set September 16th.
State of Ohio recalls Sierra Massey, case number CRB 24467, and Don Z. Gibson, case number CRB 24468.
Okay, this is a recall on bond and a possible resolution. We let the lawyers talk and see what will be resolved today or set.
Your Honor, I believe both parties are willing to agree to a mutual dismissal. However, there is a remaining issue, which is that a house trailer and possibly a little wooden trailer, is my understanding of what we're talking. Okay, so a house trailer and a wooden trailer belonging to Mr. Goodson remain on the property, and they'd like to have those removed. He'd like to get at least get his belongings out. The issue, the logistical issue that sort of stands in the way is that it's my understanding that there's some fencing between the trailers and the road that he doesn't have the ability to open and close, and that's the only route that he's going to be able to be moved out by way of. So that's one thing that's going to have to be.
The fence has to come down.
Well, it doesn't have to come down. I think there may be a gate that can be opened.
It's an electric fence.
Okay, well, de-electrified, I guess, would be the issue. Turn the electricity off for him to move, and a gate opened. The other issue is Mr. Holt saying they'd like a date that he's going to get this trailer moved. I've never moved a mobile home, but it's my understanding that that's not something you can just do. You have to have like specialized equipment, and there's probably going to be somebody hired to do that. So I don't know how we're going to give a date today to do that. So what we had discussed doing was maybe doing a 90-day continuance, come back on this thing with the intention, with the hope that everything would be taken care of, and we could do mutual dismissals, obviously with the state's assent at that point. But we do have these, the little wooden trailer, he doesn't have a problem being able to get to move. The house trailer, he has no way of moving himself. That's going to be something that's going to be
You'll have to hire that.
arranged for that to happen. So that's just, and he'd apparently like to say something.
Your Honor.
Mr. Sire hates that when people say it's on the record.
I believe strongly in the right to remain silent. I don't exercise that myself, I'm loud, but. So, I mean, I'm gonna say I don't know a way we can tell you when we can move it today. I just don't think that's logistically
A
possible.
couple of options. One, if you don't think you can communicate with each other, we could just set up for another pre-trial fairly soon. Or we could put it out 90 days and let you all work on it if you think you can come to some agreement amongst the two of you as to how you're going to get that done over the next 90 days.
Can I address what Your Honor
Yeah.
for a second? My client is okay with the 90-day continuance with the dismissal. We do want a protection order given issues that have gone on. I assume those would be reciprocal at this point. We would like, the property owners are willing, my client are willing to remove the fence. I forget his name, but Mr. Steyer's client, Mr. Goodson can remove the two items. I think we can set a day today that he can get the small trailer off. And then I would suggest we set a pretrial to give him a couple of weeks to arrange getting the mobile home off.
A couple of weeks.
No, a couple weeks to have a date in mind, not a couple weeks to have it
It
done.
took me 5 months to get my mobile home moved. 5 months, the one I got on now.
You
It
didn't
took me
understand what I
5
said.
months to get one moved. I don't know if you call 90 days or 3 months or whatever.
What he's suggesting, sir, is that we come back in a couple weeks, in a month, and at that point, we have a plan on moving it. Not that it'll be done by then, but use that time, and that, we may come in here and you say, soonest thing we can do it is 6 months from now, and if you've got paperwork showing up, I talked to someone, here's what they said, we'll make the arrangements as needed, but just so we have a plan to go forward, and we're not just saying, oh, see what happens for 3 months. I think what he's saying is just come back with a plan, and we can make that about a month out.
And then part of that, I think today we can probably pick a day that he can get the smaller trailer off.
I can move that behind. She knows.
Well, that's the point, we're gonna give you a date to do it. We're gonna give you a date to go and move it by hand. That's fine.
Huh? Don't talk to me that way. I'm not no fool. Your Honor, I've had 2 strokes and I've been in the hospital 5 times and I'm here standing before you. They got no right to treat me this way. The only way they treat me this way, that land belonged to my sister, and she died because they wouldn't let me go see her. And because they was trying to grab all the land out.
You're out of order.
Yes, sir, I am, and they are too.
I find you in contempt. Back in the back.
Just wait, sir.
I didn't want to do that, but you keep pushing.
Come on.
I don't care how old you are, how many strokes you had, you can't act like that in court. You're going to the jail.
So what does that mean?
Ma'am, you want to go with him? You're out of order. You do not blurt out in court. Out of the courtroom. Okay, I said pre-trial in approximately a month. I'll have Mr. Goodson out at the end of the docket to decide what I'm going to do with him for contempt.
Do you want me to leave the TPOs?
Yes, the protection orders remain in effect.
Would the 23rd of September work?
23rd of September works for me, Your Honor.
September 23rd will be pre-trial at 10 o'clock. And Mr. Steyer, you can talk to your client in the back, and whoever that person was that was with him that wanted to blurt out the courtroom, you can talk to her too.
I'll speak to her, Your Honor.
Thank you.
State of Ohio versus Jacob R. Nichols, case number TRC 21-1236, A and B.
This is Mr. Holt's case set for pre-trial.
Yes, Your Honor, I filed a motion this morning. This was a urine test. We are requesting an independent test. I don't know what procedure you want to follow with that. If an order from this court or the state wants to contact the lab to secure so we can have transportation to a mutually agreeable lab here locally or in Columbus, whatever we want to do. And this, it is at Mr. Nichols' expense.
Does the state agree that's a remedy available to the defendant, or do you want to look at it?
We wouldn't be opposed if it's possible, or I believe that it's
a statutory right.
He has the right, never encountered it before, so I don't know what the procedure is, but we'll do whatever, we would contact the lab and do whatever. Mm-hmm.
I'm assuming at this point, do we have the results back?
Yes.
We do.
I have a trial date, so maybe Mr. Hill and I can discuss this between the.
You want to set it for a pretrial motion? To give the state some time? I mean, I'm not familiar with the statute either, but I don't recall this ever being raised before, so.
And I never have either, Your Honor. It's also in the Form 2250, I think it's that you sign the notice of implied consent. And, it's on that form as well, but it's two separate statutes.
Hopefully, we can look it over today. We're going to need to continue this anyway.
Yeah.
Do you want to do that today, or you just want to set it for another pretrial?
Set for another pre-trial, we can talk about it.
That's fine, Your Honor.
When are you coming back, Mr. Holt?
You want to come back to the 23rd, does that give us enough time for you to be in contact with me?
What's today? 23rd of September?
I'll come back before if you want.
I don't care. Whatever you want to do.
And we understand the time would, since it's a motion on our behalf, the time would not count against the state.
Okay, so the 23rd is a good day for you? I think I just said something else.
Yes, Your Honor, that would work for us.
Okay, we'll set this for a pretrial then. Hopefully by then, the state and the defendant have agreed on how this can proceed. If not, we'll have a hearing. I'll make a decision as to how testing, if it should be allowed, and if it's going to be ordered independently.
State of Ohio versus Shannon Boggs, case number CRB 24521, TRC 1940-45. Shannon Boggs. Your Honor, this is the arraignment and the sentencing.
Except Mr. Morford's case.
Shannon Boggs?
Shannon Boggs.
Okay.
You're on my approach.
Yes.
Butch is in the hospital. That's supposed to go standing. Yeah. What car is he supposed to have? He's been all weekend. You've got a new charge here. Criminal mischief. My neighbor, but all my neighbors are. So I'm going to not guilty plea. You get this to Mr. Morford too.
Have you received the new complaint?
I did. I just looked at it. I'm going to hand it to him. Mr. Boggs has a copy of it in his hands right now. We'll get this new data in that pre-trial. We'll get Mr. Morford back.
And he has a clean screen today.
Good.
Yes, Your Honor, he's just getting started with treatment. He's had a hiccup, but he's back on the right track.
Okay, so his level of care has gone up due to that.
Yes.
Okay, his screen today is good, but last month it wasn't.
Yes.
And that may have something to do with this new, I want to presume. Do you waive a reading of the charge?
I do, Judge, and are not guilty plea on behalf of Mr. Boggs. And I assume Mr. Morford will be appointed to that one as well, and we can put that on with the next time we come back for sentencing.
He can sign a $1,000 OR bond. Is there any kind of protection order warranted with this?
Means you promise back in court on whatever day he tells you. Yes, sir. You don't have to have bonds, you just,
We may,
you're your own bond.
but Jasmine's out of the room, so.
Okay.
Hey, Roger. So, Your Honor, I want to see what Jasmine knows about that situation. This is a new charge on Shannon Boggs, criminal mischief, and I don't see the file. My question is, the judge wants to know if this, we want a protection order on this.
I don't even know what it is, I have to get the file.
Okay. Could we, if you wanted to move the docket on it, and if Mr. Boggs could just stay around until we figure out whether we need a protection order?
That's fine, Judge.
Okay, we'll recall this on the issue of bond.
Thank you, Your Honor.
Thank you, Your Honor.
Back up shortly.
When did we move his case to?
We didn't yet.
We have, yeah.
We're just checking to.
We'll wait and see what happens on the bond.
Housekeeping, I've got the bond form signed.
Okay, yeah, we can take that.
State of Ohio versus Jimmy R. Ofield, case number CRA 24225. Mr. Steyer's case, I'm not sure that he's out talking with his other clients.
One of the notes on this, the cost had been paid. My notes were, this would be continued for 90 days, which was today. Would be dismissed if there was no further problem on costs were paid, and costs had been paid.
Thank you, Your Honor. Assuming the state is going to move to dismiss?
Yes.
Case will be dismissed.
State of Ohio versus Danielle Ham, case number CRA 24229.
It's Mr. Steyer's case. This is a preliminary hearing. She's at Bethesda.
Thank you.
That's a good report.
Good job.
Thank you.
The part I like the best is Danielle's a role model for her peers. That's pretty good. That's a pretty good statement.
Yeah, I've been working really hard at welding.
Well, there's a lot of jobs out there from what I understand, if you can get your certification.
Yeah, that's what I'm going to Collins Career Center for out there.
Okay. Well, it sounds like things are going well.
Yeah.
Congratulations.
Thank you.
We've been at this a little bit, but I don't think enough to conclude things. But we can maybe give you a little more rope before you have to come back. You're doing really well, so I'm probably looking for sometime in October for your next hearing. Toward the end of the month.
Yes, sir.
Does Monday or Friday matter? 25th or the 28th would be good, Your Honor. I've got a trial on the 23rd.
Well, let's go to the 28th then.
I think that's my graduation day. Yeah.
Very good. That'll be a good day to celebrate.
That's right.
October 28th will be your next hearing, 10 o'clock.
Okay, Your Honor. Thank you.
Good work again.
State of Ohio versus Billy E. McKenzie, case number CRA 24497.
Mr. Steyer's case, preliminary hearing, he's at TTC.
I understand. This doesn't really drop. No. You've got two things here. You've got a theft and you've got a theft and a possession of cocaine. I haven't told you that this was dropped.
Yeah, Friday, Virginia. Yeah, I mean, Friday.
He has a co-defendant, Virginia McGlone, who is not set for, yes, also is his wife, was not set for today, but was set for Friday. He's indicating that charges on her were dropped Friday, and that there was talk that they would be dropped on him. Now, I wasn't told that Friday. I was aware that they were co-defendants, but I didn't really actually know that her case was set for Friday.
Well, I'd be surprised on him that he was just arraigned on August 9th.
Well, I think it may have had to do with the complaining witness or something. I don't know, I've just been told this.
The theft charge was dismissed because she was made whole of the victim, and, but not the possession charge.
Okay, so, well, I would ask then that the theft charge be dismissed against him as well, but the possession charge we can deal with through the normal.
We do that, yes, sir.
Okay, so the A case is dismissed, 497A is nolly. The B case remains, and that's the reason he's TTC anyway. So.
And do we have a report? We don't, it's just verbal. He's doing just fine. He's still in foundations. They're waiting until this court date's over before they transfer him, but the plan is for him to stay in services with us and go to inpatient residential.
And where will that be? Is that gonna be?
The counseling center.
I mean, but physically, is it like?
Portsmouth.
Portsmouth, okay.
Yes.
So it shouldn't be a problem to get back down here, so I was gonna.
No.
Okay.
And you're okay with that, Mr. McKenzie?
Yes, sir.
Okay.
So I would just, obviously we'll waive time constraints, get back in here at a time the court deems appropriate. I'm not sure what sort of time frame I want to start with at this point.
About a month.
Okay, so I think we used the 23rd for about a month earlier. I think that'd probably also a good date for this, if that would work, Your Honor.
Yes, September 23rd will be the next hearing for Mr. McKenzie. 10 o'clock. Be at TTC.
And he has a monitor on. I'm not sure if that's something the court wants to consider. If the TCC has any thoughts on the monitor, especially if he's moving into regular residential.
Well, she's not going anywhere either, so.
We want to stay on our own to finish the program anyway. Whether it's court ordered or not, I'm going to stay in it.
Is she also at TCC? Okay. So, again, just a question of the monitor. I don't know what the court's position on this at this point is.
Well, if it's being recommended by the counseling center, then I'll do it. Of course, the thing is here, Mr. McKenzie, if you leave, which I have people do that after they get the monitor removed, your warrant's still going to be good anywhere in the United States. Right. It doesn't mean that you can go to another state and escape this because it's a felony. A felony warrant's good anywhere. So, all right, I'll order ankle monitor removed. Mr. Major will take care of that.
Do you have your charger with you?
Yeah, I do.
Okay, you have to have that for it to be able to.
Yeah, I do.
Okay. Okay, so he'll take care of that. Now, he's doing everything at the court today, so give him some time.
Okay.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.
State of Ohio versus Kelsey J. Huff, case number CRB 24459.
Set for sentencing. And Ms. Huff, you don't have a lawyer?
Nope.
It's on a restraining of dog case. I think we continue this to give the state time to get evidence on if there was restitution needed.
Well, I can't still find that one. He gave me a dismissal one time. And said, I can't.
Is Jack Miller here?
Hi, her. That was me. I know him. I saw him today on my way here.
So we had urged him on several occasions to get that information for us, and he has not. So.
Okay. I'll take that he doesn't have any restitution. What's the state's position on that?
There's a new charge. Your Honor, was the dog put down? So the dog was put down, so we would just recommend a small fine for costs.
Okay, Ms. South, anything you wish to say?
Sir?
All right, well, enter a $50 fine. I'm going to suspend it since you had it all put down, and I'll restore your pay court costs.
Okay.
See the clerk.
All right, thank you.
And I've seen it because Roger had a copy. So what we need to do is...
State of Ohio versus Dale M. Thompson, case number CRB 24299. This was set for trial, Mr. Morgan's case.
This is Mr. Morford's case. It's not set till noon.
It is. And this is one that I know nothing about the case. I'm very hesitant to go forward with the trial. We talked, Philip and I did, about resetting this, maybe a week out, 2 weeks out, whatever.
Well, I think we're going to have to wait till noon.
Oh, yes, this noon, yeah. But yeah, I just think...
I'll recall it and
we'll get another day.
Where's Mr. Steyer?
I believe it's in this car, Your Honor.
Yes, Your Honor.
Are you ready to call Mr. Goodson?
I think we are, yes.
Okay, we're going to recall that then.
State of Ohio recalls Donzie Goodson.
24468. All right, Mr. Steyer, do you wish to be heard on the issue of the contempt?
Your Honor, I think, I don't think any contempt was intended. I think Mr. Goodson is just very frustrated by the situation. I discussed with him, in the courtroom, we have to keep our tempers in check. We have to keep our emotions in check. And I think that that's really what we had here, which is an outburst of emotion. He's overwhelmed. He's an older gentleman. This is his first time he's ever been in court. This is an unfamiliar setting. It's an unfamiliar set of pressures. And he apologizes, Your Honor.
All right, thank you, sir. So I'll pass on the contempt citation, order you to be released on the signature bond of $1,000. And then you need to set hearing dates on this and the other case, I guess.
Oh, a signature bond.
No, I already said it.
Yeah.
The 23rd, I think.
Yes.
If you don't come back to court, you may pay $1,000.
Okay, his next hearing is going to be September 23rd, and what I anticipate needs to happen, there's a mobile home that needs to be moved, and it's going to have to be moved by people that are professionals at doing that.
Correct.
He needs to investigate that and have a plan at least available to express to the court on that date, September 23rd, as to how that's going to happen and the date that it's going to happen. There's also another building that I understand can be removed without the use of a professional.
It's not even a building, Your Honor. My understanding is it's a little wooden trailer,
Okay.
like for hauling belongings, not.
So that can be removed before September 23rd.
Right, the only issue is even for that, I think there may be some fencing that has to be turned off, or at least some notice to them that he's gonna be there. I've given my number to Mr. Goodson and his daughter. If they can get in touch with me, I will get in touch with Mr. Holt. Maybe pick a day about a week or so out so that we can have time to coordinate all this, let them know this is when he's coming.
Okay, anything else that needs to be addressed today?
Not from this side, Your Honor.
All right, Mr. Goodson is discharged from custody. You're welcome.
You can move it back out that way.
Yep.
All right.
He'll come out in the lobby through down the hall. Okay, we have some hearings at the jail by teleconference. We're going to start as soon as we can get them online. And we've got some cases here to recall.
State of Ohio versus Jamie A. Baker at the Lawrence County Jail. Case number CRA 24547. John C. Henry is on deck. Call the jail down here.
Okay, and it looks like the audio is muted at the jail. Microphone's muted. Okay, there we go. All right, Mr. Baker, can you hear me?
Sure can.
Okay. Mr. Baker. Does he have another case pending? I think he does. Mr. Steyer?
I don't even. What was the case number, Your Honor?
This one's 24547. I think.
I have a Jamie A.
Can I hear my name, Your Honor?
Yes. Aren't you representing Mr. Baker on there's a new charge?
I don't believe I am, but I'm not going to say that I'm absolutely not. What's the name again?
Jamie Baker. This is the one that you filed the...
Oh, yes, okay, I didn't realize that was onto the docket. That ended up on the docket.
Well, it's a new charge.
Oh. Well, I would waive reading. What is the, I guess I should waive reading, something what it is.
F4 strangulation.
Is this connected to the other incident, or is it completely new?
Amy Whaley is the complaining party. It was alleged to be a family or household member.
This last one, 23, was Molly.
Okay.
My position on this is going to be the same position on the other. I would be entering a not guilty by reason of insanity and a suggestion of competency. I don't.
There's a case that was just arraigned. Was it
Friday?
Friday? Yeah. So there should be a case that was arraigned Friday. Yes. It's at 540.
Yes.
Flaunus assault. Yeah, it's the same victim.
Okay.
Just an additional charge filed.
Well, again, my position is going to remain then, especially if it's the same incident, I'm going to have to ask for a competency evaluation and NGRI evaluation. I have filed for those in the other matter. I can refile them again in this matter if necessary.
Well,
But
here's the problem that
exactly
we discussed, is that the state does not want those apparently filed at the municipal court level, because if we ask for it, the court has to pay for the evaluation itself, this
Right.
court. If it goes to, if the request comes from the common police court, then the state of Ohio pays for the evaluation.
Right.
So he needs to get to the common police court level for that to happen.
And it's my understanding that there's not another grand jury for a few weeks. Now, my position is that this matter, well, this matter would not be because I haven't filed into this matter, but the other matter is stayed until an evaluation takes place. So I would object, because at this point, I don't feel he can competently participate in a preliminary hearing, so I would object to preliminary hearing happening, but at the same time, I'm also not saying anything else should happen. We're basically in a holding pattern until that date. So if the state, we can just keep continuing this matter out until such time as he's either indicted in this case, gets nollied, or he is evaluated. And obviously, an indictment and a nollie is the more likely option.
All right, it's my understanding there's a grand jury coming up the 29th and 30th. I think we
Oh, this month?
Yeah.
I thought you were saying it wasn't until the 20th next month. I misunderstood.
It's this month. So that's what we'll do is we'll present both the pending case and this one to that grand jury.
So that's this week. Then, so Your Honor, if we set these back again for next Monday, I would, or Tuesday in this case because of Labor Day, if we set these back out for next Tuesday, I think at that point, state's likely to come in and say, he's been indicted, nollie these cases, and then I or whoever is appointed to his case at the next level can then file the appropriate paperwork then. So I would suggest that we should probably just set these for Monday, or Tuesday.
September 3rd. What's the state's position?
We intend to present this case to the grand jury on the 29th or 30th. If we came back here on the 30th, then we should have these matters resolved as to this court.
I would think Monday would be safer, but
Tuesday.
I keep saying Monday, I meant Tuesday, I apologize.
Tuesday the 3rd.
Yeah, that'd be a little safer, I think, just because that way if things get hectic at the grand jury and they get hit till the 30th, we don't have an issue of somebody needing to be here that's there, or vice versa.
All right, defendants, I'll at least agree with this far, is that you're following this request, stays the proceedings here, and case will be continued therefore until September.
And it also stays speedy trial.
Right. So September, and I'll move the other case. I had initially set it for August 30th. I'll move it, so both cases, 24-540 and 547 are now set for September 3rd for preliminary hearing. And hopefully by that time, an indictment's returned or the state decides they don't want to go forward with it.
Thank you.
Both cases are continued to September 3rd.
State of Ohio versus John C. Henry at the Lawrence County Jail, case number TRD 12-1917, A and B, and Lisa Hughes is on deck.
Sir E. John Henry? Yes. Mr. Henry, it's alleged that on June 25th of 2012 at 2:45 a.m. in Fayette Township, you were driving a vehicle without a driver's license. That's an unclassified misdemeanor, maximum penalty 500 hours community service, $1,000 fine. and that you ran a red light. That's a minor misdemeanor, maximum penalty is $150 fine. Do you understand these charges?
Yes.
How do you plead to the charge?
Yeah. Good.
Guilty? Guilty means you're admitting it's true. You understand that?
Yes.
When did you get picked up on the capias? How many days you been in jail?
2 weeks.
Okay. Well, that happened because it looks like you failed to come to court when you were ordered to.
Yeah, I was back in when, 2001?
12.
Yeah. I forgot all about it.
Okay. Any explanation you want to give me?
I'm sorry about that. I mean, I usually go to court. No, I usually don't miss court.
Okay, so on the no driver's license, I'll impose a...
I've got driver's license. I don't.
You do have one? Okay, I'll take your word for it. I'll impose a $200 fine, order you to pay the court costs, order you to do 30 hours of community service, 2 years of level 5 probation. Review hearing is February 21st of 25 at 9 o'clock. And then on the red light charge, I'll impose a $50 fine. So I'm going to release my holder today, so unless you've got a holder from another court, you'll get out of jail. So yeah,
I go to court.
Well, you've got, if you pay your fines and court costs and do your community service, you don't have to come back at all. If you don't get it finished, you got to show up on February 21st for a hearing. You can always call the court. You know where the court is in Chesapeake?
Not sure.
You know where the airport is in Chesapeake on County Road 1, Old 52? Okay, it's back toward Huntington, toward the 6th Street Bridge. You got to be here February 21st or get everything done before then. Pay your fine, court costs, do your community service. You don't have to show up then. Okay. If you don't show up, you'll get a warrant for not showing up if you got stuff left to do.
Okay.
All right, that's all.
All right, thank you.
You're welcome.
State of Ohio versus Lisa M. Hughes, case number CRA 24550, CRB 13569, TRD 08972. James Hairston is on deck.
Ma'am, are you Lisa Hughes?
Yes,
Have you received a copy of the charges?
yes.
It's a possession of drugs charge, case number 24550. It alleges that on August 24th in Fayette Township, you knowingly obtained or possessed a controlled substance, being Xanax, and that you've had a prior conviction of drug abuse. So that makes this a felony 5, maximum penalty is a year in jail, $2,500 fine. Case number 551A alleges a theft offense that at Fayette Township on August 24th, you tried to deprive Walmart of property without consent. That's a first-degree misdemeanor. Maximum penalty 6 months in jail, $1,000 fine. And the B case is resisting arrest. That on August 24th, you interfered with the lawful arrest of yourself. That's a second-degree misdemeanor. Maximum penalty 90 days in jail, $750 fine. So those are the new charges, and then you got old charges. You got a prior theft from 2013 where it's alleged you didn't do community service that you were ordered to do and failed to appear for a review hearing on October 7, 2013. And a traffic case from 2008 where you had driving under suspension and failed to appear for a review hearing on October the 7th, 2013. So those are all pending. Do you understand those charges?
Yes,
How do you plead to these charges?
not guilty.
Do you want a lawyer appointed?
Yes, please.
Mr. Smith, I'll appoint you.
Yes, sir.
Roger Smith's going to be your lawyer, ma'am. Well, I didn't even ask you about your income. Do you have any income, ma'am?
Yes,
Do you have a job?
yes.
What do you do?
I do home health.
Paid by the hour?
Yes,
How much per hour?
11 something an hour,
How many hours a week?
30.
Okay, you're eligible for court-appointed counsel. And I'll appoint Mr. Smith. I've got a Catlettsburg, Kentucky address. Well, I've got a Catlettsburg, Kentucky address, and I've got a Huntington address.
One is my grandmother's address and the other is my mother's. The 1912 Virginia Avenue is the address.
And whose address is that?
That's my grandmother's house, that's where I live at.
Okay, since she's failed to appear before, I think I'm going to be required to set some sort of cash or surety bond. Is there any bond you can post, ma'am?
At this time, no.
I'll set your bond at $1,500, cash or surety,
Was that 150?
probably. That's up to the
Okay.
bail bondsman, but that's most likely it. You think you can
Okay.
post that?
Yes.
Okay.
Can I get a phone number, Judge, if you
Do
post
you
it?
have a phone where Mr. Smith can reach you?
304-730-4961.
730-4961.
Yes.
Okay, thank you.
So you want a bail bondsman to contact you about posting bonds?
Yes.
I can get over Mr. Sowers, Judge, when we finish here.
Okay. What's the state's position on bond?
We're not opposed to the cash or surety bond. I guess, given the circumstances, we kind of thought that there might be some drug issues involved, that we'd want her to start some treatment.
Is this a case you would consider leaving here if she did go to treatment?
Yes.
So here's I'm going to throw a lot of legal stuff at you at once, but try to absorb as much as you can. You can talk to your lawyer about it. You're charged with a felony. Felonies are the more serious charges. A felony means if you're convicted on it, you can go to prison. Before you can be convicted of a felony, you have to be indicted by the grand jury. So that's a group of your fellow citizens that meet and listen to the prosecutor's evidence and say, yes, no, we think there's enough. And that's called an indictment if they say there's enough. What the state's saying is they're willing to let you go to treatment and not even take you to the grand jury for an indictment. But that means you're going to have to go to treatment, come back here to court periodically, show me that you're in treatment, and that you're getting good results, and that you're going to be clean. If you do that, you'll never get indicted. You won't have a felony on your record. You won't even have an indictment on your record. The case would be dismissed, but it's going to be pretty far down the road. Is that something you're interested in?
Yes.
Okay. Have you been in treatment before?
No.
Okay. Do you have a West Virginia medical card?
Yes.
And you're living in Virginia Avenue, Huntington.
Yes.
Okay, let me, ProAct is an agency that you can go to that's in West Virginia.
Okay.
You can go to Marshall Health,
Okay.
and that is ProAct. That's the one on 20th Street and 8th Avenue. You can walk in there and get evaluated. You can go to OBP, and they're on 20th Street about 6th Avenue, I think. So same neck of town. You can go to Valley Health. So those are some agencies that we work with in West Virginia where you can go get assessed and treated. You have to come back, you'll have to come back to court and show me that you're in treatment. And that you're doing what you're supposed to do. And if you don't show up, I mean, if you have a bond up, Mr. Sowers, if you post it through him, he's very diligent about tracking people down and getting them into the jail if they miss court.
I'm sure.
Okay, so take this opportunity to get clean. Do what you're supposed to do, get clean, and don't, get this case dismissed. I mean, that's about as good an outcome as you can have. You get clean, you get your case dismissed. Now, you still have these other old cases you gotta take care of too. So let's set a hearing date for you when you have to come back to court. Now, you're sure you're gonna be able to post bond?
I hope so, I don't know.
Well, maybe we need to come back sooner than later. I don't want you sitting in jail for weeks, you thinking you're out on bond and you're not.
I'm here Friday, Judge. Tuesday, I've got something with Judge Farrell. I could be here later, but I'm here Friday morning. I don't know if that's enough time to...
Well, that's not much.
I could do two. If you do about 11 on Tuesday, I could do it.
That should be fine.
Okay.
I'm going to set you for next Tuesday.
I can do that.
Okay,
That's September 3rd.
okay,
So you got to get out and go get an assessment and come back to court and show me you've done that.
okay,
And if you don't, I'm going to issue a warrant for you and tell the bail bondsman to go hunt you down and take you to the jailhouse.
okay,
You understand that?
yes,
And you're telling me you're going to be in court. You know where to come to for court?
yes,
Hole 52, across from the flea market.
yes.
All right, September the 3rd, the day after Labor Day, you got to be in court.
I'll call you before then. We'll talk about the case.
Juanita, do you want to try to get in touch with her?
She's got West Virginia.
Oh, that's right, you can't do West Virginia.
Like for that, I would.
Okay.
I'll get hold of Mr. Sowers, Judge.
State of Ohio versus James Hairston, case number CRA 24552, and Christina Gilmore will be on deck.
So are you James Hairston?
Yes.
I'm Judge Capper at Lawrence County Municipal Court. This is your arraignment hearing. What you say is going on the record. It can be used against you. You have a right to remain silent. You don't have to say anything. You have a right to a lawyer. You have one appointed if you can't afford one. You have a right to bail and to make the state prove these charges beyond a reasonable doubt. You understand those things?
Yes.
You're charged with having a weapon while under a disability. It's a third-degree felony. The state's alleging on August 23rd in Rome Township, you were under a disability from having a firearm or dangerous ordinance because you were under indictment or had been convicted for a felony offense involving possession, use, sale, or administration of drugs of abuse. So this is a felony of the third degree. The maximum penalty is 5 years in jail and an $8,000 fine. Do you understand the charge?
Yes, sir.
You have the money to hire a lawyer?
Yes.
Have you hired a lawyer?
Yeah, I hired a lawyer.
Okay. Well, let's back up. Do you have money with which you can hire a lawyer?
No.
So you want a court-appointed lawyer?
Yes.
Are you working at all?
Not at the moment, no.
Do you have any income coming in?
Not at the moment, no.
All right, is Mr. Steyer still here?
I am, Your Honor.
All right, Mr. Steyer, I'm going to appoint you to represent James Hairston. It's a third-degree felony having a weapon under disability charge. State's position on bond. James Hairston, Hairston.
State would request a $2,500 cash or surety bond.
What amount?
$2,500.
2,500. Do you understand, sir, that if this court were to grant that bond request, it would cost you about $250 to $300 to get out of jail?
Yes, sir.
Do you believe that's something you could do if I got you in touch with the bondsman?
Yes, sir.
In that case, Your Honor, we would join in that request. He believes he can meet that bond, and I would ask to set this, presuming he's going to make the bond, we would have 15 days to bring this to preliminary hearing. I would ask to set this for the 3rd. I would just set another hearing for that date. Or did I say the right date? I'm sorry, because of the Tuesday.
Next Tuesday.
Yes, the 3rd. So I'd ask to set this for the 3rd.
All right, I'll set the next hearing, Mr. Hairston. And I see you've got an Athens address, is that correct?
What?
Athens, is that where you're living? You have a different address?
I got a Gallipolis address.
Okay, do you want to give us that?
It's 258 State Street, Gallipolis, Ohio.
And do you have
phone number?
Do you have a phone number, sir? Do you have a phone number?
Yes.
Can I have that, please?
It's 740-339-9614.
And is that a cell phone?
Yes, sir.
Okay, I'll send you a text message. When you get out, please text me back. We'll arrange to speak.
Sir, you have to appear in court on September the 3rd, which is a Tuesday. Usually court's on Monday, but Monday's a holiday next week. So the day after Labor Day, you got to be in court at the municipal court in Chesapeake, Lawrence County Municipal Court. It's County Road 1. Are you familiar with where that is?
Yeah.
Okay. You got to be here at 10 o'clock on September 3rd. Okay, that's all.
Thank you, sir.
State of Ohio versus Christina Gilmore and Melissa LeGrand is on deck.
Hey, Luke. When are we coming back?
The 2nd, or the 3rd, rather. The 3rd.
Okay, this is Christina Gilmore, is that your name, ma'am?
Yes.
Well, I have some good news to deliver, I believe. I've just been told by the bailiff that no charges are going to be filed against you. Is that correct, Mr. Bishop?
Yes, Your Honor.
So unless you got a holder from another court, there's no new charges filed and you'll be released.
Okay. I helped for Gallagher County, I think.
Okay, well, you'll have to go to Gallagher County. They'll take you, since it's a county that touches Lawrence County, there's no hearing required. They'll just take you to Gallagher County and you have to, I can't dismiss the charges up there. So you have to address the court in Gallagher County.
Okay.
Should we just do one that we handwrite?
Whatever, there's no charges filed, whatever they need to release it to Gallagher County.
Okay.
Okay, that's all, ma'am.
Thank you.
You're welcome.
State of Ohio versus Melissa D. LeGrand, case number CRA 24513, CRB 24462, and Logan T. Wright is on deck.
This was also Mr. Morford's case. He's not available today due to illness. All right, then you're Melissa LeGrand.
Yes, sir.
My last order was for you to go to inpatient treatment at Bethesda with an OR bond and an ankle monitor, and I think I've been informed that you left treatment.
She went to King's Daughters, was physically abusive to our nurse, so we could not take her back safely. And common police, and we couldn't go across the state line to get her, so they released her. But she was the one I spoke with you about. She had audio and visual hallucinations, and it wasn't well. It wasn't good at all.
Is that part of the detox?
No, the King's Daughters was very familiar with her.
Okay. Well, Mr. Morford's not here today, so the only thing I think I can do today is continue to Friday if he'll be here. Then I'll revoke the OR bond. I'll reinstate a $5,000 cash or surety bond and reschedule her case for a hearing coming up this Friday, which is August 30th at 10 o'clock.
Okay, can I speak?
You can, ma'am, but everything's on the record that you say.
Okay, so anyways, they take me to Cassandra, and they said I was a threat to 16 people. I did not touch nobody. The girl took me over to King's Daughters, and she left me there. Okay, and then King's Daughters kept me. I told them to call Marks County Sheriff's Department to let me out. And they said they was above the law. King's Daughters Medical Center did. Then King's Daughters Medical Center said they went to court for me. So I don't know how they went to court, but they had me over there for a few days. Then Phoenix came and got me, and I told them to call the probation officer. They did not call. They went in and transferred me back to another rehab. So then that rehab up there was more like they wanted to couple up as boyfriend and girlfriend. So I asked to be removed of that because I wanted to go to a rehab that was more on a Christian-based program. And I would like to see if you could send me to a Christian-based program, Your Honor, because I did not put my hands on anybody.
I'll consider it on Friday. I mean, your next hearing will be Friday.
All right, waste of time, all right.
Thank you, Your Honor.
He's lying.
State of Ohio versus Logan T. Wright, case number CRB 24512A and B, and Anna Schaefer is on deck.
Mr. Smith's case set for pretrial.
It is, Judge, the current status of this, well, he is on a hold out of Ironton on a probation violation set for a hearing September 5th. I don't know if the alleged victim is here on this one today. I want to proceed.
Brianna Fugate. That's Ironton Municipal Court. He's got.
Yes, by John Kincaid. He comes back the 5th of September for a hearing in that court. We're hoping to somehow get these, run this time with that time and get him back in that court, but I don't know if she's here.
Well, we didn't ask her to be here today, but we have been in contact with her, and she feels that she's been victimized by him. Now, we do believe, because of this case and the case in Ironton, that there are significant substance abuse issues which are causing him to have all these problems and being violent towards other people. He's in jail awaiting a probation violation hearing. It's going to be September 5th, so he's going to be in jail for that length of time. I guess what we would suggest is that if he wanted to go ahead and plead guilty to these charges, we would recommend that we find out what kind of sentence he's going to get on his probation violation in Ironton, and then recommend to the court something that is kind of in keeping with that sentence, which I believe it's going to involve jail time and probably some more treatment.
The only problem I have, Judge, I have not I've not filed discovery. This one was not, I really hesitate. I would like to come back September 6th, and then that'll give you a chance to file discovery. I'm not saying I'm rejecting the offer, but I really do need to talk to him in private about it.
All right, next hearing is going to be September the 6th for pretrial, 10 o'clock.
I'll come down to jail and talk to you, Logan, okay? He's talking like me. Hopefully he could hear us.
All right, your lawyer's gonna call down and talk to you.
Yes.
State of Ohio versus Anna Schaefer, case number CRB 24549A and B, CRA 23442, CRB 23443A and B. Brandon Spencer is on deck.
All right, Anna Schaefer, that's you, ma'am? Your audio is off, so I can't, I see your lips moving, but none of your audio is coming through. It's probably turned off at the headset. Now I can, yes. I'm Judge Capper. I'm at the Lawrence County Municipal Court in Chesapeake. This is your arraignment. You have a right to remain silent. You don't have to say anything, but if you choose to make statements, it's all on the record and be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove the charges against you beyond a reasonable doubt. You understand those things?
Yes, sir.
You've got a theft offense from Walmart and a trespassing charge from Walmart. It's alleged in 549A that on August 24th, you purposely tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. And at the same time, you trespassed on Walmart's property without their consent. That's a fourth-degree misdemeanor, maximum penalty is 30 days in jail, $250 fine. Do you understand those charges?
Yes.
And then you've also got pending a case 23442 and 443 from a year ago, and that was 23443A was a theft offense from Walmart. July 22nd, 2023, that you allegedly tried to take property from Walmart then, first degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Same date and time that you also trespassed on the premises of Walmart, fourth degree misdemeanor, maximum penalty 30 days in jail, $250 fine. And then you had a separate charge for identity theft, same time and place that you were holding yourself out as another person without the right to do so. So that's a felony 5, identity fraud. Identity fraud.
Well, I got a divorce and I didn't know I had to go back to court and take my next action with granted. But that's why that is, I gave the end of the granted, but my name is Chris Schaefer, so it's my married name. I didn't know I had to go back to court and I came to that.
Okay. Okay, you had left treatment, it looks like, back a year ago. I let you go on an OR bond into treatment at Bethesda.
Yes,
For
but
inpatient, you didn't stay and left.
I was 4 days sick and they just left me laying there. When they took out insurance, I was just sick.
Okay.
I want me to have so bad, I want to get better.
Do you have the money to hire a lawyer?
No.
Do you have a job? Mr. Smith, I'll appoint you.
Yes, sir.
You want to do Roger Tyler with her attorney on?
Is Tyler gone, or?
He's gone.
Okay, we'll appoint Roger on both matters.
Okay.
So, Taylor, do you remember her? You need to do some research.
I need to do some research. I'm not for sure.
Call her, or call and get some information. Do you have a medical card, Ms. Schaefer?
I used to in Ohio, but I don't think I have one in Ohio anymore.
Do you have, excuse me, do you have one in another state?
West Virginia, I think.
Have you been in treatment in West Virginia?
No.
Have you ever been in treatment before?
Yes.
Other than the time you were, I think you were at Bethesda like one day.
No, I was at the counseling center in St. Lucie. for like 2 years.
Did you graduate from that program?
Yes.
Okay, well, I'm gonna have, we can look into getting you treated either at some place, but you're probably gonna have to wear an ankle monitor now, since you left before. You wanna talk with her?
You don't mind, I'll call down the jail while we're checking on the other.
Okay, I'm gonna have your lawyer talk to you, and you may have to talk to a treatment provider also for an assessment, so.
And borrow the court's file.
You can have the court's file. I'll have you recalled after those things happen. We'll decide where you're gonna go and what your bond's gonna be.
State of Ohio versus Brandon Spencer, case number CRB 24-535, CRB 13-488, TRC 12-570, TRD 10-1147A and B, CRB 9-610. Mr. Holt's case.
All right, this is Mr. Holt's case.
This is Monday around so you may need to do a protection order.
Mr. Holt, this is Brandon Spencer.
Your Honor, I hope today is the bond posted so that Mr. Spencer can get out and we can address this matter.
He thinks he can postpone?
No, I haven't spoken to him about
Oh,
that.
okay.
I'm hoping to get a warrant on it. There's been interest in time. I believe this is the only reason he's in jail.
He's got a bunch of old cases.
I mean, but this court.
Yes. Well, I don't know about other courts. But he's got several files here.
Is it outstanding fines or community service?
Looks like some of them are just pending, never were resolved. There's a DUS, so that one doesn't have too much left on it. There's OBI that wasn't completed. I mean, he was sentenced, but he never finished what his sentence was. And there's criminal damaging that was still pending, never resolved.
That's a new one?
No, that's from 2013. And then the new case, menacing, 24-535. That's the only one I've got.
Is the criminal damaging one as well?
It's all. Okay.
Yes.
Look at all his cases, I don't have it written down.
Okay, 24-535 is the most recent. 13-488. 12-570. 10-1147. 09-610.
Mr. Spencer, the state has, and it's obviously pending court approval, they would be willing to, I believe, agree to an OR bond to get you out if you would agree to go to counseling, go to treatment. I guess we'd have to do an assessment and depending to determine on what type of treatment you need if you're interested in that.
Yes.
Do you have a medical card, Mr. Spencer?
Yeah.
Ohio?
Yeah.
You still living in Proctorville?
Yeah.
Have you ever been to treatment before?
I did treatment while I was locked up. I'm in my substance, but I was locked up 2015.
Okay.
2023.
Oh, you hear that?
You never done it locally then? Never done it in the local area here in Lawrence County? Is that right?
Yes.
Mr. Hill, you agree?
Yes.
I think that probably, explain the reason why there's certain cases pending.
Yeah. Okay, I'm going to give him a $5,000 OR bond, signature bond. I'm releasing on your own signature. I'm going to order you to OVP in Proctorville. Do you know where that is? Next to Ace Hardware. You know where Kroger is?
Yes, I know where Kroger is.
He has a parole holder.
Oh, okay.
Yes.
So,
You're going to have to get them on board.
yeah, I'll find out what their intention is. So, I
Set
guess,
it for Friday?
yes.
I can't be here Friday, Your Honor. I have 2 days, 10 hours of debt on both days.
Okay. Tuesday, next week?
Okay.
Is that the 3rd?
That's the 3rd.
Could I do it by video conference?
Yeah. He can still go ahead and sign an OR bond just in case they're gonna, if they decide to release the holder. You got a holder from the Adult Parole Authority. So even if I order you out, you're still not getting out because they've got a holder on you.
Right.
So your lawyer will talk to them and see if they're on board with you going to treatment. They may agree to that. Or they may not. I mean, I can't guarantee you one way or the other.
Right.
I can call APA right now, Your Honor.
You want to do that before?
Yeah.
Okay, I'm going to let him call them now and see if he can get some kind of verbal commitment from them as to what they want to do. Then we'll have you back after we get that.
Do you have like his case number? Does Matt? His guy?
State of Ohio versus Melissa S. Thompson, case number CRB 24548.
The judge didn't tell me. They just said he has an APA. It's all right.
Ma'am, are you Melissa Thompson? Ms. Thompson, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. What you do say is all on the record. Everything, you're appearing in court on a monitor. Everything, your image, what you say is all being recorded. If you say something that helps the prosecutor, they could play that video and use it against you. You have a right to have a lawyer, to have one appointed if you can't afford one. You have a right to bail and to make the state prove this charge beyond a reasonable doubt. Do you understand those rights? The charge against you is theft from Walmart on August 24th, Fayette Township, that you tried to deprive them of property without their consent. It's a first-degree misdemeanor, maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
How do you wish to plead to this charge? Guilty means you're admitting it's true. Do you understand that? Okay. I'm going to order you do a urine screen. Do you think you can give a urine screen? Because what I find is about 80% of the people that shoplift at Walmart have dirty urine screens, and then I order them to get treatment. So I'm going to order you go do a urine screen, then the jail will give me the results on your urine screen, and I'll see you after I get those results. So this will be recalled after we get your urine results. I don't know, can you give a urine sample? Some people will say, I'm going to be here for a little while longer. If you say, I can't give a urine sample, I'll just continue it to the Friday, and we'll wait till you can give one. I'm not going to just say, oh, I'm not going to do a urine screen then. So, do one, let me see the results, and then I can decide what kind of treatment, if any, you need. Okay? I'll see you back after you do the urine screen. Okay, that's all we can do at the jail. We've got some, like hers, we're coming back there after we get some additional information.
State of Ohio recalls Shannon Boggs, case number CRB 24-521, CRC 19-2045.
All right, and this is a case that Mr. Morford is the attorney on, and we're going to decide about bond.
You do want a protection order?
Okay, so there is and you were contacting the victim to see if they want a protection order?
Yes.
Okay. This is Shannon Ball.
Yeah.
The protection order is for Melanie, Melanie, Butt, B-U-T-T. So, Mr. Boggs, I'm going to order that you not go around or contact or post anything about Miss Melanie Butt. Is that any problem?
No, sir.
That'll be a condition of your bond, $1,000 or bond. And then Mr. Morford's your lawyer. I'll appoint him on this new case. You're to continue with RRS for counseling as you have been. And come back for a pretrial. Let's make it September the 6th. So that's a week from this Friday. Hopefully Mr. Morford will be back then. September the 6th will be your next hearing.
Thank you, sir, Your Honor.
You're welcome.
Thank you, Your Honor.
State of Ohio recalls Justin Michael Reaper, case number CRB 24226.
All right, and this is a case with Mr. Morford as the attorney and you're...
Yes, Judge, we called earlier, we're going to be for 7 days, he is here. We need to get a date for Mr. Morford's client, sit down and talk to him and come back if we could.
Well, I just set one for September the 6th.
That'd be fine.
All right, next hearing is September the 6th.
He's not available the 6th. The 13th, is that okay? It's Friday the 13th.
That's fine, September the 13th.
And I'll tell Mr. Morford September 13th.
September 13th, 10 o'clock is the next hearing.
I'll let
Mr.
Susie know.
Reaper.
Yes. Thank you, Judge. And I'll tell Susie that new day, so she'll have her call me now and just talk about your case. Is Luke still here?
State of Ohio versus Dale M. Thompson, case number CRB 24299. Second trial today.
Dale Thompson? Still not named.
Still not in.
Perhaps in about 10 minutes, Judge.
Just when I turn it into the computer, I think I clocked slow. State of Ohio versus Jillian E. Burris, case number CRB 24398. Jillian Burris.
This case is set for trial today at noon. You're Ms. Burris.
Yes, sir.
Do you have a lawyer?
No.
State, want to go forward with this?
Yes, there's a co-defendant, and that is Ms. Gardner, Keely Gardner.
State of Ohio versus Marquia A. Gardner, case number CRB 24399.
Is the state looking to try it at the same time, or looking to set trials?
Did you want to talk to me about this?
Sure.
Okay, these are gonna be for evidence, or you need to talk, so we got other cases we can do. So I'm gonna put this off until they talk, and we do these other cases, get them out of the way. Anna Schaefer.
Ms. Schaefer was ordered to us on July 24th of 2023. We went to the jail to get her, and she ran from the jail. So she never was even at our facility.
Okay.
And they asked me to do an assessment on her for ODP, I guess.
Is she in custody, or?
I believe.
Yeah, that's her.
Yes, she is, yes, she's in jail. And Roger is her attorney, so maybe she has.
Yeah, Roger came to me and asked me to do an assessment.
All right.
Because she has,
We need Roger Smith in the courtroom.
3 files.
I just get her.
And you got some files on them.
Oh, yes,
Yes,
I copy.
Schaefer.
I'm sorry. Be careful. Can you grab those files on the copy machine for me?
Yes.
Thank you.
Okay, here she is. She's back up on this.
Yes, Judge, I talked to her. She is willing to engage in treatment. I explained the situation with the ankle monitor and what will happen, not might happen, will happen if she cuts the monitor off. I don't think Bethesda was interested, but perhaps OVP because of West Virginia component of the medical card.
So they're gonna call down and do her assessment to see if we can take her.
Okay.
So as soon as
I need the
hear
files.
something.
Yes, there are Bob's copy. They should be coming right back. I'll do this tomorrow.
Oh.
How do you rubber band? It's on the copy machine.
So she can go to OBP inpatient with an ankle monitor.
As long as she qualifies.
Okay. You're willing to go inpatient, Ms. Schaefer?
Yes.
Okay, to make sure this happens, let's put it on the docket for Friday.
I'm here. Yes, sir.
Okay, I'm going to order you released to OVP for inpatient treatment on the docket for the 30th, just to verify that you are there.
So will I not go there today?
Well, if we can get an ankle monitor placed, then we should be able to. You should definitely be there before Friday, and then I'll get a report that you are there and you're doing well. Now, you've talked to her about the significance of the ankle monitor.
Did, Judge, you might want to reiterate, I said it might be 3 years, it will be 3 years in prison if she cuts it.
Yeah. The cutting the ankle monitor of itself, just that act, is going to get you a felony, and it won't be up to me. It goes to the common police judges, the felony judges, and they have kind of staked this out as their position. They take it really serious because they don't want people cutting ankle monitors. Everybody that's done it has got at least 3 years in prison just for cutting the ankle monitor off. So, do you understand that? I mean, this is serious. It's not like, oh, I'm going to get slapped on the wrist. We're not doing what I was supposed to. No, you're going to go to prison.
Yes, sir. I'm ready to get better.
So, You gotta go to treatment and do what they tell you to do, how they tell you to do it, when they tell you to do it, get good reports. If you don't think you can do that, you'd be better off just saying, no thanks, I wanna sit in jail for a while longer rather than get out. The last time you didn't even make it through the door, you bolted immediately. If you do that this time, when they catch you, it's not gonna be county jail time. It's gonna be bye-bye up to Marysville. Do you understand that? And I'm not joking about it. I think, I've told this to other people and they didn't think I was serious. They were just trying to scare me. Every person that's done this so far has gone to prison. If they cut the ankle monitor, they have gone to prison. And I'm not the one that sends them there. You understand that? Okay, so I'll see you hopefully on Friday. You'll be at OVP, get a good report, and we'll go from there. So this Friday at 10 o'clock is the next hearing. Subject to her being approved for acceptance. So.
Thank you, Your Honor.
Thank you, Judge.
You're welcome.
Your Honor, we have Brandon Spencer and Melissa Thompson still remaining at the jail, but we're not ready for those yet. Been told anyway.
Well, there's some other people sitting in the courtroom.
You're looking at Mr. Thompson, Butch's new trial. Yep, Thompson.
State of Ohio versus Dale M. Thompson. Case number CRB 24299.
There's no one in the lobby.
All right, it's afternoon now. He was scheduled for a trial at noon. He's failed to appear, so there's going to be a warrant issued for his arrest.
I'll let Mr. Morford know, Judge.
Your Honor, if I could address the court a little bit on that issue. This is a case in which the evidence that we intended to present today shows these pit bulls. These are actual pit bulls running in and out of that house.
Hang on, he's showing up.
Good.
All right, this is, Mr. Thompson is here. His case is set for trial today, but his lawyer is in the hospital, so it's going to have to be continued.
Yes, Judge. I don't know nothing about the case, so I would prefer it be continued and Richard Morford can be here.
Let's set it for September the 13th for trial at noon. That's at the defendant's request since the lawyer is not here.
I'll sign a time waiver, Judge.
Okay, your next hearing, Mr. Thompson, is September the 13th.
Okay.
Noon.
Call Mr. Morford, get his card.
This is an ongoing, very dangerous situation involving a whole house full of pit bulls. They attacked a man. We've got pictures of them. They just absolutely mauled his leg. This is not a situation where he got nipped by a chihuahua. This is two pit bulls knocked the man to the ground.
Well, they're not two pit bulls.
Well, there were two that knocked him to the ground. One of them tore his leg apart. He's had to have surgeries, and they continue to menace the neighborhood.
No, they don't.
Well, we have video to show it. I mean, I have sympathy for this gentleman, but at the same time, he doesn't seem to care about what the neighbors think about his dog.
offense to that, that he doesn't care.
There's nothing I can do.
No, I just can't. We're coming back. I don't know what to do, Judge. I don't know nothing about the case. It would be malpractice if I were to just pick up a file and start reading it.
Yeah, I agree. It'll have to be continued. September the 13th, if you got new events, follow your charges, and I can do something on the bond.
Just make sure you keep your dogs.
My dog is secure.
Okay, sir, your case is continued.
I'll tell Mr. Wolford, your new court date, but give him a call. And keep him secure till then, after.
State of Ohio versus Marquia A. Gardner, case number CRB 24399. State of Ohio versus Jillian E. Burris, case number CRB 24398.
Your Honor, this is one that I had not had a chance to talk with Mr. Holt about, and I was hoping we'd have a few minutes before we started the trial.
Okay, we can take a recess. Is there anybody else's case that hasn't gotten called? Directed the bailiff to come talk to you, man.
What do you hear, Brian? Okay, we'll find the file and let you know what's going on.
All right, court's going to be in recess. We'll advance a new case, as I heard, arraignment order, so that's the first hearing. So we'll see if the charges have been filed. Court's in recess.
For roll call, I said to.
Yeah, no, I get that. Determined.
One after twice. He has been saying about every time we take it.
This is strange. I lost my phone.
Yes, is that it?
No, I've got my phone, it's my phone.
That is adorable. Is it?
We'll see if there's sorry.
I mean, he's good. Like a straight ass.
You too.
I'm gonna stay with this trial, so I don't have to go back.
I wish I could say that, but my office is too close.
Yeah.
Have a good day.
You too.
Here you are, Philip.
For some reason, they didn't make the service like us, and that's the reason that we didn't have a file. We're not found the file, so now we got it ready to go.
It happened.
It happens. Really sorry that you had to be here that long, because we would normally have been very good.
Especially when I were calling people when it was scheduled for 12 and trials and all that.
Okay. There's 3 different charges.
How's it going?
Going.
Good day.
Did you check in at the clerk's office when you first came in?
Checked in with the guy who was doing.
Yeah, but he should have told you to check in with the clerk's office.
Yeah, no, he didn't tell us.
Yeah, okay.
But then someone called his name and checked.
Well, yeah,
while
that
we
was,
were in here.
yeah, that was because we have a computer listing of all the people that are supposed to be here for different kinds of cases that are here on. And they just called the attendance thing, okay. But since you didn't check in with the clerk didn't know that you were here, and that's where everything would have been filed in there. And he should have told you. It's a real mix-up because he probably looked at that listing of all that and saw his name on it. He thought it was something to it anyway, and I understand that. But somehow.
We're not repeats, so we didn't know what to do.
It's very difficult to understand. You haven't been through it, I know.
Thank you.
I want to have you as a witness to see what happened.
I'm gonna lay this here for Philip this side.
Well, I'm going to ask you what actually happened. You were the one there.
Right.
You got Paul there?
You all right?
Yeah, as long as I didn't fall, I'm fine.
I have, not yet.
Man, I'm not trying to handcuff you to sleep or anything.
The way she addressed me when she came in the house, if she was spoke to me like we're talking right now, there would have been no officer. She was talking to Chris. I'm back that way. I'm not doing this with you.
Yeah, well, I understand people get highly upset about these things, and it gets, it's toxic. Right.
All right, that's that. Hold on, let me find me something that's. I don't even have a, like, all my schools are full, the people get that,
And I'm guessing that you helped take care of that dog while
We
you're
still got to call back, if you ever go to jail, though.
you know, I could say, well, you're just as responsible as she is, but at the same time, I
I have-
hope you don't be the right thing.
Yeah, Melissa
But I also
Thompson,
want for the
Brandon
court to know from your
What about
perspective,
Gilmore?
since they're, I'm assuming.
No, because we,
Let him charge.
Yes, no.
yeah,
Amazing.
I got to do jail rates, but I'm gonna go.
Being.
I'm gonna go ask
Because they didn't take the charge.
That's the reason that arrest started back to our
Okay, what's that?
so she could get her dog. And she had first.
And I don't have any problem with any of that. The one thing that that there's a law, if
Should be able to sue.
Yeah, I thought.
It's A, B, and C.
Yeah, because this is what, that happened.
that's a problem.
Yeah, that's what it is.
She has his own interest.
Yeah, okay, so we're good. I need to go out and see.
Yeah, and that's, that, make sure you don't mess around again.
Absolutely. Okay.
Philip, I laid something there for you to sign.
Okay.